Hello class, and welcome to your first screencast for Advanced Legal Research. As you can see, we'll be discussing secondary materials. More specifically, I'm going to try to answer the question, why bother with them? This screencast will be somewhat of a review of what you went over in legal writing in first year. My hope is to refresh your memory and so that we all start on the same page. So let's get started by defining our terms. What are secondary resources? Well, I'm going to start by defining what our term is not. So what secondary sources are not are primary sources, or what I like to call the law. More specifically, the law is basically what's produced by the different branches of government. So we have the legislative branch, so they pass laws, and if it's signed by the executive, you have a law. Speaking of the executive branch also issues or promulgates regulations. And then last but certainly not least, there's the judicial branch that makes decides all of those cases that you've been reading throughout law school. We're going to go into far more detail on all of these sources of the law. In fact, it'll comprise most of the course, but that will be later on in the semester. So let's get back to discussing secondary sources. So we know what secondary sources are not. What are they? Well, essentially it's just jargon for materials, or I like to say stuff, that's going to help you find the primary sources as well as understand the law. So the different types of secondary sources, you talked about these again in legal writing. You start in the least specific, the most broad or general are legal encyclopedias. I call them broad or general because they cover lots and lots of different topics, starting from A, abandoned property, through Z, zoning, and everything in between. So it does not go into much depth for any of those topics. You have general jurisdiction encyclopedias like AmJur and CJS, and you also have state-specific encyclopedias like New York Jur. You talked a lot about restatements in your first year, which of course are basic statements of the law, which are published by the very well-respected American Law Institute, and that's comprised of expert practitioners and law faculty. There's also something called ALR, or American Law Reports. I think of this as a hybrid between legal encyclopedias that are very broad and law reviews or treatises, which are more specific, which I'll explain in a moment. So if you find an ALR article, or sometimes called annotation, on your topic, you get a great start for your research, but you won't find an ALR article on every single topic. So let's talk about law reviews. Of course, you've read a whole bunch of these by now for your classes. Law reviews are articles by experts, faculty, sometimes practitioners. They are essentially prescriptive. Law review articles will argue what the author thinks the law should be. But in course of making that argument, the author will also tell you what the law is and give you references to what the law is. And then on the most specific end of the spectrum, we have treatises. Again, treatises is just a fancy word for book, or really title, on a particular topic by an expert. So you'll have treatises on constitutional law, or even more specific treatises on First Amendment law. Unlike encyclopedias that cover a whole bunch of topics, a treatise will just cover one topic, but it also means it will go into more depth in that topic. You have different flavors of treatises. You have treatises geared toward practitioners. You have something called a loose leaf. We'll go into more detail on what that is later on. So let's answer this question at hand. Why should you bother with secondary sources? What can they do for you? So a short answer actually comes from a law firm librarian. Hopefully somebody working with attorneys on a daily basis has some credibility with you. So this law firm librarian talked about the top 10 things law librarians wish new associates would know. And her number 2 thing is that before you even log on to any database, get some background with a resource, like a secondary source, different types of secondary sources. And so you want to get that background. You want to get started in that issue. That secondary source is going to give you the context of your issue. The broader, it's going to give you that bigger picture. It's also going to give you definitions and terminology, as well as references to primary sources. So that's the short answer, which actually gives us part of the longer answer. Again, secondary sources are going to provide you with those references to the all-important primary sources. They're going to help explain the law in regular English as opposed to legalese. And speaking of legalese, secondary sources are also going to identify that terminology, that legalese, which is going to be all important for researching your issue. Remember promissory estoppel from contracts? Well, if you need to research a issue regarding promissory estoppel, you need to know that terminology. And if you don't, you're going to find it very difficult, if not impossible, to identify resources on that concept. Secondary sources are also going to help you identify potential issues. Does your particular issue involve a 3-part test or however many part test, and you have to start thinking about those different elements, those different parts, and how that applies to your client and how that applies to the issue. Secondary sources are going to give you a more complete understanding, so you can get your arms around the issue, more of an overview. You sometimes cannot just answer the very narrow question that your issue presents. You need to understand the broader context of that area of law. Secondary sources are also going to help explain some of those conflicts. I'm sure you've talked a lot in class about 2 cases that seem to say the opposite things. Secondary sources will help explain that. And secondary sources will also help you keep up to date. Is the law changing? Was there a new case decided? Is there a new statute being considered? So that's the longer answer of why you would use secondary sources. So when would you use the particular types of secondary sources that we talked about? Well, I'm arguing you should certainly start with secondary sources, but I'd also strongly recommend that you use secondary sources throughout your research process. So of course, as we said at the beginning, you want to get an introduction to the concepts, terminology, and issues. Encyclopedias are particularly useful for this, as are ALR, but you're not going to just use encyclopedias in the beginning of your research process, nor will you only use them in the beginning or only use encyclopedias at the beginning of your research process. In the middle, it's sometimes really good to follow up to get more in-depth explanation, to follow up on newly discovered questions, and this is where treatises will come in particularly handy. And again, you won't only use treatises in the middle of the process. Sometimes you'll start with a treatise, and you won't only use treatises. You'll use other types of secondary sources in the middle, and likewise at the end of your process, you want to make sure you have all the primary authority. Again, treatises can be really useful for that. You also want to make sure that your analysis is up to date with any current developing areas. This is where current awareness sources are particularly useful. Again, you won't only use current awareness sources at the end, you might even use them in the beginning, and you'll use other types of resources as well. Research is issue specific. You need to be flexible in your approach. You frequently won't determine what the best strategy is till you have started and are well into the project. So that's why I am repeating that you will be using these different types of secondary sources at different points throughout the process, and it won't always be the same. Okay, so we talked about when to use different types of secondary sources. How is the best way to use secondary sources? Well, there are different types of resources within those secondary sources, as you can see listed here. So let's look more specifically at them. So here is an index now. This is from a print treatise. Actually, you'll find indexes in other secondary sources as well. You'll also find indexes online, and it pretty much works the same way. So if you are interested in the UCC, you will see different aspects of the UCC in the pages that you'll go to, but you'll also see a reference here that says see also sales contracts. And what this is telling me is that I'm now in the U portion of the index. I want to either flip back the pages or scroll back online to the S portion of the index so I can look under sales contracts. If I am interested in substituted agreement, there's nothing listed under here, so there's no page immediately to turn to, but what the index is telling me is to see discharge. So again, I'm going to flip back the pages to the D portion of the index for discharge or scroll back up to D. If I were interested in unconscionability, again, it starts to list some aspects of unconscionability in the pages under here, but first, as you can see, it tells me generally 380 et sec. What on earth does et sec mean? Well, honestly, when I see et sec, I am really excited. Why? Because what it's telling me is I want to go to page 380 and following. That's what et sec means, and following. So pages 380 and following, I'm going to find a discussion of unconscionability. So I'm going to get a more in-depth discussion than perhaps I would get with just a single page reference, as you can see here. So that's how you would use an index, again, in print or online. Another really good resource in a secondary source, frequently treatises, but other sources as well, is the table of contents. I happen to think that the table of contents is much underappreciated. Yes, it's going to tell me what page I'm going to find the particular chapter on, but it actually does a whole lot more. So as we can see here, chapter 9 is from a treatise on contracts, avoidance or reformation for misconduct or mistake. So yeah, I get the page numbers, but it's also telling me what are the different parts of this concept of avoidance or reformation for misconduct or mistake. So there's apparently duress is related to this. So is undue influence. Under an undue influence, here I see, here's one of those issues that has elements of the particular concept. So I am already learning about contract law. I know undue influence has elements. I know that undue influence and duress are related to this overall concept. I have learned the terminology. If I discover my concept is actually undue influence, then I now know that terminology. I can type it in and do further research on undue influence far more effectively than if I didn't know that term. I can't tell you how many times I have turned to a table of contents, again in print or online, for a particular resource, maybe a treatise, maybe a statute compilation, and I have learned the terminology, I've learned a little bit about the issue, and it's really made my research far more efficient as well as effective. So that's the table of contents. Another way to use secondary sources, of course, are keyword search online, of course, and you can do this on the 3 legal databases we'll be spending a lot of time with. It's pretty straightforward, pretty easy, and it works the same on all 3. We'll be going into far more detail on how to effectively use secondary sources on the 3 different services and some of the advanced search techniques. But for now, just to get to those secondary sources, pretty straightforward. You type in your search, or this is one way actually, keyword searching. You type in your search, and then once you've typed in your search, you can filter to your type of resource, in our case, secondary sources. Works the same way on Lexis. You type in your search. Once you've done your search, you filter your search to secondary materials. Absolutely the same on Westlaw. So keyword searching is one way to use secondary sources. We'll talk about other ways of using secondary sources on these 3 databases in the next few classes. Okay. So one thing you want to make sure to do when using secondary sources, and really any resource, is to update, update, and update. You're going to hear me say this a whole lot of times throughout the semester. This is really critical because the law is changing daily, cases decided, statutes passed, repealed, amended. So you must update your research and find what the law is today. You may think that going online, going on Lexis, Westlaw, Bloomberg means you automatically have the most up-to-date resource or an up-to-date resource, and that's not necessarily true, especially with regard to secondary sources. The underlying resource, the underlying article, treatise, whatever, may only have been updated last in 2010. Likewise, if you go on the web, I'm sure you've encountered web pages that were last updated 10 years ago. You need to be aware of the characteristics of the resource that you're using. This is that bibliographic awareness concept we talked about in first class. In addition to updating, and updating, you want to make sure to gather your primary sources and, of course, read them. Secondary sources are wonderful. Don't get me wrong. They're a fabulous place to help you with your research, but ultimately you need to read and understand the law. Another good practice is to keep track of your research. Keep a log. We'll talk a little bit in class. I'll give you some tips on how you might go about this. If you get interrupted, say you're working on one project and your supervisor comes in and pulls you off on an emergency project, and 2 weeks later you come back to your first one, you want to have a sense of what you checked, where you've been. You don't want to have to start all over from scratch. You want to be very, very careful when you're using secondary sources on Lexis and Westlaw. They may not be in your contract, and if they're not in your contract, they will cost major dollars. We've been talking about how Lexis and Westlaw are priced. Notice I don't say Bloomberg. Bloomberg is a flat fee, so Bloomberg, you don't have to worry quite so much about cost, because if you've already subscribed to it, you've already paid what you're going to pay. Okay, so we've reviewed what secondary sources are. We've defined our terms. We talked about why we care, how they're going to help you, how to use them, what to watch out for. Let's talk about how to find them. Now we're going to go into a lot more detail about these different methods for finding secondary sources in the next few classes. Just for now, I will highlight a couple that you might not have thought about, and that is, of course, good old Google. Well, yes, of course, you've thought about Google, but there are specific ways of using Google that might help you find good secondary sources. There are databases out there other than Lexis, Westlaw, and Bloomberg, topic-specific databases that can also be useful. And yes, we'll talk about looking at blogs and websites found by Google or other methods. So as you're using secondary sources, you want to evaluate them as you go. A lot of students, it seems, get caught up in they have to find something in this particular source. And that's not necessarily the case. Is the source shedding light on the problem? Does the secondary source help you? Obviously, if not, see if you can find something else. Or if not, did you classify the problem properly? You might remember in first year, the librarians gave you a hypothetical about grandparent visitation. And some of the students, you were all first years at the time, of course, got a little bit sidetracked and thought it was a custody issue, which of course is very different than visitation. Or they got a little sidetracked having to do with the divorce decree that was issued prior to the grandparent seeking visitation. You want to make sure you're focused on, you classify the problem properly, and you're focused on the problem at hand. Another aspect you want to keep in mind, in light of new knowledge, do you need to revise your preliminary questions? Again, going back to our grandparent visitation hypothetical, in some states, some of you would have discovered that the test actually is the best interest of the child. Well, that's new knowledge. It's also perhaps an additional question. So you may need to start researching what does best interest of the child mean in your particular jurisdiction. Okay, that's it for now. You want to make sure you are logged into TED-Ed so that you can answer the Think questions. See you in class.